Welcome to Case Law Minutes by LitigationHelp.com, your public legal education provider. My name is Huizinga, and in this video, we are going over the case of Glick versus Cale, 2003 ONSC 893, which is a Superior Court of Justice case from 2013 that deals with assessments and when they should be ordered. But first, we need the disclaimer. This presentation is for general legal information only. For advice specific to your case, please consult a lawyer. The facts of the Glick and Cale case are as follows. One child of the marriage, married November 2008, child born April 2009, separated April 2010. Both parents retained lawyers, attended open mediation. After 4 months, the mediator resigned. The mother brought a motion seeking Section 30 from the Children's Law Reform Act assessment, but it was dismissed. Later, the mother brought a second motion seeking an assessment. The judge discussed the authorities with respect to when an assessment should be ordered. The judge established a new non-exhaustive list of criteria which assists the court in determining if an assessment would be helpful. The judge then applies the list to the facts of the case and grants the request for an assessment. With respect to assessments, the justice found at paragraph 48, I have endeavored to provide this non-exhaustive list of criteria which might assist a judge in deciding whether to order an assessment. A. What was the parenting relationship like before separation? Did the parents function at least adequately before the separation and the dysfunction arose after separation? Are the parents able to make any decision about the child's needs, including education, religion, health, and activities without intervention by the court? C. Without defining high conflict, is the relationship between the parents so unhealthy that one or both parents are unable to identify the best interests of the child and act on it? D. Do the parents have a mutual disregard for the other parent's ability to parent? E. Do the parents blame each other for the dysfunction each describes? F. Is there a clinical diagnosis that might impact on the parenting capacity of one or both parents? G. Is there a clinical diagnosis with respect to any of the children in the family unit that means the child is fragile and vulnerable to ongoing conflict and has special needs? H. What is the age of the child at separation and at the time of the request for the assessment? I. Is the parenting manifesting behavior that might be associated with stress caused by the conflict between the parents? J. Is there an alternative? For example, is the child of an age and maturity that his or her views should be known, and if so, would it be more appropriate to ask the OCL, which is the Ontario Children's Lawyer, to become involved and appoint a lawyer to act for the child? K. Are there other challenges in the family, such as whether the family home must be sold? If those challenges are resolved, will the family dynamic be improved and avoid the necessity of an assessment? L. What is the basis upon which the moving party relies? Is it essentially a mobility case on which the court must hear evidence? Is the issue custody or access? Custody is now known as decision-making, and access is now known as parenting time. M. What is the estimated cost? Do the parents have the financial resources to pay that cost? N. Will the assessment cause delay that is not in the best interest of the child? In considering the impact of delay, is it more likely than not that the delay necessarily involved in an assessment will enable the parents to have a better understanding of the family dynamic and arrive at a resolution without trial. Is the assessment in the best interest of the child? You can get this case from CanLII.org using the link in the description below the video or the link displayed in the video. Thank you for taking the time to watch this video and tune in to other videos from the most cited list of family cases. Thank you.